Hello and welcome to this webinar hosted by Thomson Reuters, in which we're going to examine some of the complex procurement issues flagged up to us by subscribers and clients. My name is Owen Willcox and I'm the Procurement Editor at Practical Law, and I'm pleased to say that we're joined today by three procurement specialists who are going to address these issues. They are, and they're shown on the slides as well. Initially, Michael Bowsher, Queen's Counsel of Monckton Chambers, Rebecca Rees from Trowers and Hamlins, and Michael Rainey from Addleshaw, Goddard. Time permitting, we aim to look at four areas: contract modifications, Teckal, past performance, and Consortia bidding. And if there's any time available at the end as well, we'll try and answer a few of your own questions if you raise them in the course of this webinar. Otherwise, we'll save all your questions and deal with them separately, or if anything occurs to you afterwards, you can always send it through to me at Thomson Reuters Practical Law through the Ask mechanism, and I will deal with it then. So what I propose to do is just briefly introduce each topic, and then we will deal with the questions. And Michael Bowsher has kindly agreed to help out with the variations questions. Just to begin by reminding ourselves at a high level what the context is here for modifications permitted by Regulation 72. And I've got a very high level listing of the areas there on the slide. Those provided for in initial procurement documents, additional works not included in the initial procurement to be carried out by the original contractor. That would include services or supplies as well. Changes arising from unforeseen circumstances, contractor changes in the circumstances provided for in the regulations, and non-substantial changes, which of course are effectively defined by the definition of substantial changes, low value changes, and if we need to, referring to what is now the leading domestic case, the Supreme Court decision in Edenred, which did actually look at a couple of those issues. So what I'll do now is move on to the questions that we're going to start considering, initially with variation. These are the first ones up on the screen, and the first one is asking about the provisions of Regulation 72 and whether they apply to these various scenarios. And Michael, would you mind addressing those initially, please?
Okay, thanks, Owen. It's a pleasure to be here. Let's see. So, the variation of below threshold contracts, are they covered? Well, technically speaking, I suppose it's a little bit odd whether or not they're covered by Regulation 72 or they're just covered by the general principles, and no one's actually tackled that question. I'm not sure it matters terribly, because Regulation 72 is largely just a restatement of the general principles of EU law. I mean, you could argue it probably either way, but I suppose what you really have to look at is the nature of the change, because the theory, of course, is the whole theory underlying modifications is it's the change which is to be treated as making the entire contract a new contract. So either you say, well, this was a below threshold contract which was originally which wasn't covered, but the change is in some way a substantial modification and is therefore a breach of principle, or well, there are a number of different ways of putting it. It's a little bit hard to. It's a little bit hard to answer as a question in the abstract because, of course, there is a specific provision about value in Regulation 72.
Yeah.
So I was trying on the way here to work out what is this change to a below-threshold contract that isn't, in fact, going to fall within the value exception under the change. I mean, it would presumably be a really rather large change to a below-threshold contract. Given that the threshold itself is the same threshold.
Yeah.
So almost axiomatically, if it's going to be bigger than that threshold, the contract is going to be more than doubled. But it seems to me, I mean, even if you could even have a situation where the change was such, even if the value was fairly small, it so changed the nature of the contract that because you're not covered by Regulation 72, you're still into a substantial modification below the threshold. You wouldn't be dealing with ineffectiveness because you wouldn't be under the regulations, but you'd still have the possibility of a judicial review because you'd be in breach of the general principles. It's a rather tangled analysis, but it's a little bit odd depending how the situation arises.
Sure. Yeah, that's very helpful. Thanks. What about contract extensions?
Well, in principle, I mean, doesn't they always be potentially? They're always going to be covered by by Regulation 72 if the threshold applies.
Yes. Yeah.
I mean, you just have to take them through go through the analysis under Regulation 72 to see whether it applies or not.
Yes, thank you. Yeah, assignment and novation are other areas that seem to exercise quite a number of people, and I guess we ought to take those separately, starting with assignment. Do you have a view on that?
Well, again, I'm not quite sure. It depends whether we're talking about assigning or novating on the purchaser side or the provider side. I mean, if you're talking about assignment, you would have thought, technically speaking, would be an assignment of the benefit, so you imagine that's going to be assignment to a different contracting authority or a different utility.
Yeah.
So the question is then presumably going to be whether or not that changes is a substantial modification. Well, it might be and it might not be. I mean, quite likely if it's just a question, it may be that you don't have a provision dealing succession of purchasers. You've got the provision to dealing with succession of providers. But I mean, if a department or a local authority ceases to exist and its activities are just transferred across and contracts are assigned, although probably wouldn't be assigned, but they are transferred, then there's probably no change at all. But you can imagine how, if you move a contract from a local authority to the Ministry of Defence, almost axiomatically, the contracts probably change rather radically just by being moved. And if we're talking about the transfer of the provider or the contractor, then I think they plainly are covered because, although again the regulation's a little bit odd in the way it's worded, you've got an express provision in 72(1)(d dealing with circumstances in which a transfer to a different contractor that sort of by reverse reasoning, it must mean that therefore there are an awful lot of circumstances where you are covered by Regulation 72.
Yeah. And that would apply to novation as well, do you think?
Presumably. I mean, well, sort of even more so, as it were.
Yeah.
I mean, the problem with a lot of this is that in a lot of these cases, people use words like assignment, and when you look at what they actually called an assignment, it's not an assignment. It's actually often a document called an assignment is not, as a matter of law, an assignment. It's actually more likely, it's actually really a novation, because it's very difficult actually to deal with all of the issues that arise under these contracts by a pure assignment, because you can only you can't transfer all the rights and liabilities on both sides under an assignment. Yeah, novation
can be neater in that respect, can't it?
Yeah.
And then something I think we've partly touched upon, but seems to concern a number of people is whether or not, looking at it the other way, if a value of an above threshold contract is significantly reduced, whether we think that could amount to a material variation under under 72 as well.
Well, I think it must be possible that it does. Again, I think the Court of Justice recent decision, which is impossible to pronounce unless you're Danish. My Danish students tell me you have to swallow it at the back of your throat. Finfronde.
Well, that's how you pronounce it. Please.
The G is very subtle. Anyway, F-I-N-N-F-R-O-G-N-E. I mean, that tells you that at least it could be.
Yeah.
Well, although that's a case with, I think, nearly a 90% reduction, but I don't think that the number is really the point you're getting at. You're talking about what of a substantial reduction? Well, the answer is theoretically yes, but and I don't think the fact. I mean, it's an interesting point that if the reduction takes the value of the contract from being above threshold to being below threshold, is that really relevant? I'm not sure it really is, because I mean, no one's ever had to deal with a case where, as it were, a contract was varied, so it stopped being of a certain cross-border interest. I mean, all sorts of odd points would arise.
I mean, I think when we advise clients, one of the issues here is who would that contract now be attractive to. So if you are, by either substantially increasing the value or decreasing the value, are you then making that contract attractive to a wholly different class of business? And if you are, then it is unlikely that you'll be able to enjoy one of the safe harbours provided by Regulation 72.
Because you're into substantial territory, you mean?
Yeah. The financial safe harbour here is a bit alluring, but it's a bit of a siren call rather than a safe harbour, because it suggests that if you have a low value change, a low value increase, that's exempt, and that would suggest that if it's no value or negative value, it's also exempt, but that isn't necessarily the case, I think, as we've discussed. If it changes the overall nature of the contract, then it's something to which the exemption wouldn't apply.
I mean, your last question, I mean, this is obviously a point that's very much relevant to call-off contracts, but also lots, so it's going to be an increasing issue as more and more people get used to using the increasing pressure to use lots. And one of the issues which I've not seen thrown up here, but I've seen thrown up in France, is a whole issue about the sort of consequence of this is the need to be much more specific and accurate about the values of frameworks, the values of call-offs, and particularly the values of lots. And of course, without naming names, we all may know some contracting authorities or utilities whose approach to publication of values has been less than totally accurate. That may become, for all the reasons that Rebecca said, that may become very important, because particularly with a policy which is going to be increasingly driven, I think, by sort of pro-CME, SME policies, the whole point is to chop things up in a way that makes them available to SMEs. Well, what's the point of doing that if you're not going to actually publicize it in a way? And if you end up with a contract which could and should have been available to a smaller group of suppliers, but you put them off just by putting the wrong number in the notice, I mean, that in itself might actually be quite a substantial breach.
With call-off contracts, which you've alluded to there, do you think if you're looking at potential variation of a call-off contract, your first point of reference is the framework itself, in terms of whether you've made provision in the framework for such an eventuality, or should you start with the call-off contract and see if there's anything specifically in there which governs how that call-off is to be managed? Because that's an area under 72 I've found a little bit difficult to think through myself.
Right. I think that's fair. It's a difficult thing through for fair reason. I mean, it comes back to what is the review clause that does Regulation 72 let you look at a review clause, and if so, where should it be? I mean, it refers to the review clause being in the initial procurement documents. Well, I suppose that means that if the review clause is in the draft of the call-off contract and was tendered on that basis, then it's in the initial procurement document. But if you've cobbled together and made up a review clause as part of the call-off process, then presumably you can't rely on you can't even start thinking about it being a relevant review clause.
No.
I mean, I think
that must be right. Yeah.
There's a bit of a layered approach when it comes to framework agreements, because I agree with Michael. The initial procurement documents is likely to include a draft framework agreement and a draft call-off contract. So if you are seeking to vary either one of those contracts, and you anticipate that, you would expect to see two very, what do they call it, clear, unequivocal and precise review clauses in both of those documents.
Yeah.
I think one of the most common variations that we would see in practice is where people are trying to use the framework agreement to call off goods, work, services that are not covered under the framework agreement, either partially or to the fullest extent.
Yeah.
So that is when this question normally comes up, in that I'm seeking to call off something that may only partially be covered by the framework agreement, either due to value or scope, and that's when we tend to look at Regulation 72. And in that scenario, I would be looking at the framework agreement governing any review clauses or in respect of call-offs to be made. If there is then a variation to be made once that call-off contract is being performed, then you often adopt a layered approach, which is first look at the call-off contract to see if that in itself can be varied, and then you look at the framework agreement to see if there's anything that you could hang your hat on in that document.
Right, yeah.
Another place practically we quite often see changes in the framework context is the award of centralised framework agreements like the CCS framework. And then somebody who obviously wasn't involved in the original putting together of the framework agreement or call-off terms wants to call off under the framework, but finds that the call-off terms are not quite the terms it would want to put in place, and so they change the call-off terms before calling off. And it's slightly difficult to analyse what that change is actually to, but the risk is that the call-off contract is just simply an unlawful direct award, because it's just not within the framework, because the terms are different, although we may be within scope in terms of the goods and services.
I mean, if you go through the analysis that the Supreme Court went through in Edenred, it's a slightly pointless restatement of the test that they did, but in a sense, those examples illustrate. You do have the problem that particularly with call-offs, which if you're changing a call-off, it's usually because you've got yourself into a situation where the modifications probably weren't exactly provided for in the initial procurement documents, and almost by definition, to use the Supreme Court's phrase, the clause doesn't have the required degree of specificity, because it isn't quite what you thought you were doing, so you didn't anticipate that's what this clause was really going to cover.
Yeah. That's very helpful, thanks. So, what we'll do now is move on to Teckal, and again I'll just very briefly introduce this, and Michael Rainey has kindly agreed to lead off on this one when we come to the questions. Just to say, if people are not already familiar with Regulation 12, essentially what this is saying is that public contracts will fall outside of Part 2, where there is another entity apart from the contracting authority over which the contracting authority exercises what we'll call departmental control, which is also defined in that regulation. More than 80% of its activities are entrusted or contracted to it by the controlling authority, and there's no controlling direct private capital participation in the controlled legal person. The definition of the required level of control is, as I said, is defined, and it's there on the slide. And also, just to mention that there is provision in Regulation 12 for joint control of an entity by more than one contracting authority. And there are also in Regulation 12.2 what we call the reverse Teckal provisions, which make provision for the Teckal entity effectively awarding contracts to its parent. And so, moving on to look at some of the questions that we've been asked about Teckal companies, starting with one that's often raised is whether or not a Teckal company, could it actually be a contracting authority in its own right?
And the simple answer to this is yes. And the slightly more complicated answer to this is it may or may not be, depending on how the Teckal company is actually set up. So yes. Regulation 12 doesn't really deal with this. It does acknowledge in 12.2 that a controlled body is not necessarily going to be a contracting authority in its own right, because it says where a controlled person is a contracting authority. So what you have to apply to the Teckal company is the usual rules for establishing whether it's a body governed by public law. And those usual rules are set out in Regulation 2.1, and there's 3 limbs to that test, which I'll just show everyone's aware of, but I'll just repeat those now. First part of the test is that the company is established for the purpose of meeting needs in the general interest and doesn't have an industrial or commercial character. Second part is that they have legal personality. And the third part, which is an or, is that they're financed mainly by contracting authorities, subject to management supervision by contracting authorities, or more than half of the board is appointed by contracting authorities. And if any one of those is present, limb 3 is satisfied. So when you compare that test to the Teckal test that you've just read out, with the control condition, the activity condition, and the no direct private participation, it's clear that in most circumstances, a Teckal company to fall within the Teckal test will also fall within the body governed by public law test. Certainly, limb 2 will always be satisfied. It always has to have separate legal personality. The third limb almost certainly has to be satisfied in order to satisfy the activity and control criteria. So then you fall into looking at the first limb and whether the Teckal company has a commercial or industrial character. And if it doesn't, it will be a contracting authority and it will be caught by the rules. The likelihood in the overwhelming majority of cases is that it won't have a commercial character because it's got to perform the essential part of its activities for its controlling contracting authority. So it is possible to envisage circumstances where it does have a commercial character. I have to say I've never come across those circumstances, but it's conceivable, and it's not absolutely definitely the case that all Teckal companies are contracting authorities.
I suppose in the sense that the 19% is probably not enough to satisfy the market operation limb or criteria. Is that the point?
So doing 19% of your activities on the market is probably not sufficient to give you a commercial character, particularly when you're completely supported by your owning contracting authorities in terms of strategic decisions and that sort of thing. It just insulates you from market forces.
And it's often that the link and the relationship between the contracting authority and Teckal company will mean that there will be a level of additional support. So some of the case law around industrial or commercial character has been, do they bear the risks of the market that they operate in? So not only do they have a fair wodge of business that's naturally going their way from the controlling contracting authority, but it's likely that behind the scenes the contracting authority will guarantee them, pick up risks. There's also often an ability to gift aid any profits back up, or certainly send profits of the Teckal company back up to the contracting authority, all of which, even when taken with your 19%, 20% market activity, seems to suggest that it doesn't have an industrial or commercial character. So, like Michael, it would be very rare when you actually get a Teckal company that would not be a contracting authority.
Sure. Moving on to another issue now about joint control, and the second question, which is essentially, can a jointly controlled Teckal entity award contracts to its controlling authorities without a procurement process? So this is where the entity has more than one controlling contracting authorities.
So this is a particularly tricky question. Regulation 12 is one of the more codified areas of the newish directives, and it's codified the case law that was there before, and it's gone an awful lot further by introducing some new concepts that weren't actually in the EU case law before with the codification. But it hasn't gone quite as far as it might have done. So it's gone as far as permitting reverse Teckal, which is the Teckal company awarding contracts back up the chain to its controlling contracting authority. It permits joint Teckal, which is the key theme of a number of the Teckal cases. That it's a jointly set up Teckal body with a number of controlling contracting authorities. Almost all of the big name cases, including Teckal itself, involved a jointly controlled Teckal company. But what it doesn't permit in Regulation 12 is reverse joint Teckal, which is where the jointly controlled entity back up the chain to one of its controlling entities. And this happens quite often in practice with sort of shared services, Teckal companies, where they may be set up to perform a particular shared service, but there might be some function that they don't have in that Teckal company, and they want to award a contract back to one of the owning authorities for something like payroll or HR or something like that. So it does happen fairly often. It's not expressly permitted by the rules. My view would be it should be permissible, because all of the case law about joint Teckal is that the jointly controlling entities, the Teckal company, is effectively an in-house body, in-house department for each and every one of those controlling entities. Yes. The case law is very clear on that, including in the UK, the Supreme Court in the Lamel case. Very clear that that's the analysis. So why reverse Teckal wouldn't be permitted is not entirely clear, but it's just not in the codified regulation, so that there is a level of risk in relying on it because it's not there. It's never, as far as I know, been dealt with in any cases. But it should, going back to first principles, be something that is permissible.
Yeah. That's very helpful, thanks. And then, still on the theme of reverse Teckal in 12.2, question: do the reverse Teckal provisions allow for the award of contracts to third parties? Effectively, the Teckal entity awarding contracts elsewhere. I think that's what that question's getting at.
Yes, and so Regulation 12.2, which deals with reverse Teckal and also horizontal Teckal, which is two controlled Teckal companies awarding contracts to each other. It does not expressly include the 80% test or the essential part test. It's not in there. It includes the other two limbs of the Teckal test that you set out earlier, but it doesn't include the requirement that 80% of the activities are performed for the controlling contracting authority. So it's not entirely clear why that's not in Regulation 12.2. It does appear to be in the equivalent provision in the underlying directive, although again, that's not a picture of clarity really. It just says paragraph 1 also applies. Whereas what the UK regulations say is it also falls outside the scope of this part, so it doesn't link it back to paragraph 1. So there is no 80% test in there. The question then is there supposed to be an 80% test in there? And if there's not, what does that mean? So I guess there's three options that the 80% rule does apply, as the directive suggests. And interestingly, in Scotland, they very clearly do have the 80% rule in their regulations for reverse Teckal. So there's a more restrictive rule, which is what this question is getting at, that in fact the controlled entity should perform 100% of its activities for its controlling authorities and no activities outside of that for third parties. Or thirdly, that there's no essential part test at all, and that the controlled body can perform as many services as it likes on the open market and still take advantage of reverse Teckal, which seems very unlikely. So the first of those options probably seems the most likely, which is that the 80% rule is supposed to apply in Regulation 12.2. Quite why it's not in the UK regulations, I'm not sure. Other people might have a view on that. And that means that the control entity can award 19+% of its activities on the market without losing the ability to rely on 12.2.
I mean, Michael, if this came into court, what would you have an easier task in doing? Arguing that the 80% does apply, or that the 80% as in Scotland and Europe, or 8% doesn't apply?
You must have a reasonable fight on arguing back to the directive, I think. It is a bit odd, isn't it? I mean, I don't remember this coming up in any of the consultations on any of this. So I presume this is just a product of the copy-out process, isn't it? I think. I've not really followed it through. I imagine it's just an artifact of the copy-out method of implementation, which obviously was not being applied in Scotland. And if it's that, and it's consistent with the underlying logic, then you probably would have a good argument.
Yeah, the Scottish regulation is a complete redraft.
It's exactly, it's quite the opposite of copy-out.
Interesting. Thanks very much for that. Now move on to past or poor performance, as we've referred to it here, because it's often poor performance or perceived poor performance that exercises people's minds and give rise to operational issues. And again, just briefly to summarise the operative provision in Regulation 57.8, which basically is a discretionary ground for excluding an applicant, where essentially it can be shown that they've effectively significantly underperformed in relation to a prior public contract, and that's led to defined circumstances, early termination, damages, or other comparable sanctions, which I don't think has been further defined. And the other point to make is that this is also underpinned by a couple of key procurement policy notes, which we've shown on the slides. The most recent one is 816, which, amongst other things, provides guidance relating to the evaluation of past performance of a potential supplier, as well as dealing with a new selection questionnaire and statutory guidance in relation to the field of selection. And then PPN 0415, which basically deals with specific central government contracts above a value of 20 million. So we have a few issues to deal with in relation to this, and one issue that seems to come up fairly often is whether there's any sort of crossover between grave professional misconduct and poor contractual performance. And the question there actually is, could grave professional misconduct amount to poor contractual performance? And Rebecca has kindly agreed to deal with these.
Thank you, Owen. Well, when thinking about this, I think normally grave professional misconduct probably wouldn't amount to poor contractual performance unless it was impacted on the contract in a way that led to early termination, damages, or comparable sanctions. So an example might be that a director or somebody in charge of the company has committed fraud through the performance of that contract, in which case it could do. But I think taking a step back, actually you don't really need to conflate the issues. You've got a right to exclude discretionary exclusion on the basis of grave professional misconduct. You've also got the right to exclude for poor contractual performance, provided that the means are met on your previous slide, so that there are persistent and significant deficiencies of a substantive requirement, and that's led to one of the sanctions on early termination. So in that sense, you don't need to see that grave professional misconduct amounts to poor contractual performance before you sort of boot someone off your procurement. What I would say is that the discretionary exclusion isn't the only way we take poor performance into account in the selection process. There is the ability to ask for certificates of performance, or in the UK we usually ask for references. And in that sense, if someone has, or a company has committed an act of grave professional misconduct, even if it doesn't give rise to the right to exclude them under the discretionary exclusion grounds, it can still lead to the giving of a poor reference, which then can impact under Section 3 of the SQ selection questionnaire in marking down the bidder. So it could amount to poor contractual performance. I haven't seen it before, save for the fact that if unsavoury things have gone on under previous contracts, it would normally result in an unsatisfactory reference. Whether or not a bidder ever provides those references under an SQ is another matter.
Thank you. And then touching on a kind of a related issue, which is can the alleged grave professional misconduct of a director be taken into account in all circumstances? I think that's really what that question was aimed at.
Sure. I mean, we discussed this offline, and I think there are two issues to this question we think that this question might be alluding to. Firstly is the alleged nature of the misconduct. If you have heard on the grapevine that a director has been guilty of fraud, but it's not been taken to court, it's not been convicted, can you take that into account? And there is Court of Justice case law that seems to suggest that you are innocent until you're proven guilty, and not only that, that rights of appeal have been exhausted as well. So I would be very nervous in advising a client that they should kick somebody out or exercise their discretionary right to exclude on the basis of a rumour or allegation.
Yeah.
Secondly, this question gives rise to the absence under Regulation 57.8, she says, quickly flicking to it, of a similar provision that's included under Regulation 57.2 in respect of mandatory exclusions,
yes,
where it quite clearly says that you have to exclude a bidding entity if the person convicted of the fraud or collusion, etc., bribery, is a member of the administrative, management or supervisory body of that economic operator. So obviously in your question, a director of a company would quite clearly be a member of the administrative, management or supervisory
yes,
body of the company that they're seeking to exclude. Now, a similar provision isn't included under the discretionary exclusions. And so what do we do about the absence of that? If you have a look at the other grounds for discretionary exclusion, it includes, for example, conflicts of interest. And if you go back to Regulation 24, where you're looking at the definition of conflicts of interest, it includes conflicts of interest that arise because of the interest of the individuals of that economic operator. So it seems to me that by cross-reference, you must be able to exclude under 57.8 if a director of that company has committed or has been found guilty of an act of grave professional misconduct. But Michael and I were, actually, Michael, Rainey and I were talking before, when we were sort of saying, well, okay, there is a bit of a lacuna in the regulations here. So what we'd probably advise clients to do is make it very clear in their selection questionnaire that actually when answering these discretionary exclusion questions, we want the bidders to state whether any of these exclusions apply to the directors or officials of that company. Now, you can either do that by adding questions into Section 3 of the selection questionnaire, and we often find those in terms of breaches of environmental regulations, health and safety regulations, etc. So that's done. Or you could amend Section 2 of your selection questionnaire to basically apply Regulation 57.2 to the discretionary exclusion grounds. Now, if you do that, of course, you've then amended Section 2, which means you need to send a reportable deviation to report to the CCS.
Yeah.
But actually, that might not be a bad thing, because there is certainly, you know, a gap that we're not too sure how to deal with here. So at least then the CCS knows that there's a gap in guidance here, and could potentially issue another PPN just to confirm that apparent lacuna. So
that would be helpful, wouldn't it? That could be cleared up. And then the other question on performance relates to effectively a candidate who's bidding for a contract with an authority, has had prior contracts terminated by that authority, but has not declared it, or possibly sought to hide it, which I understand is not so uncommon. And the question then is whether the authority can exclude that bidder and be pretty confident that they won't be successfully challenged.
So I think the short answer is yes. I think one element to this question is, can the contracting authority use itself as a reference or its own experience to evaluate the discretionary exclusion grounds? And the answer to that is yes, it can use it. Again, as with the previous question, we would make it very clear in the selection questionnaire that if you have done work for the contracting authority previously, then please include those as examples, and include the contract manager, project officer, or whatever as a relevant reference. Clients are often nervous about that because they don't think that that is treating bidders equally. But the principle of equal treatment doesn't mean that you have to treat each bidder the same. So, of course, incumbent bidders have many more advantages than incoming bidders. So I don't think that the principle of equal treatment prevents you from taking into account your own experience. Secondly, what happens if they haven't declared it? Well, practically what you'd do is you'd go and remind them and ask them to clarify their response. But if you look in the standard selection questionnaire now, there is a question in there that says that actually one of the discretionary exclusion grounds is if you misrepresent or fail to include information that is subsequently induces the contracting authority to award a contract to that bidder, actually gets the bidder in quite hot water. Yes. But practically, prior to excluding for poor performance, grave professional misconduct, failure to disclose, whatever, you have to look at the treaty principles, and one of the main ones in this respect is proportionality. And we do have this concept of self-cleaning at the selection questionnaire stage. So before you exclude them for answering yes to any question, one thing is, well, what is the nature of that poor performance? How long ago was it? What type of contract was it for? Is it actually relevant to your contract? Would it prevent them from successfully delivering your contract? And then secondly, have they had the opportunity to self-clean, and have they self-cleaned? So, sorry. Excuse me. Have they put procedures in place to make sure that that grave professional misconduct or the actions that have led to termination of a previous contract, have they mitigated those or removed that risk? Do the directors actually even work for the company anymore? So all of that stuff, you do have to act proportionately. So, and you do have to verify the information that they give you. So, again, if they don't declare it, you know, there is an element that you can, you are allowed to verify and correct that or exclude them for that. Again, if they have answered yes to any of the questions, they are given the right to self-clean and declare what those self-cleaning measures are, and you do have to go and verify that before you exclude them.
That's excellent. Thanks very much.
Another thing just to add with the last question is the risk of a conflict of interest being alleged. If you have the person who is managing the incumbent's contract involved in the re-procurement exercise, and they then try and take account of their fairly nasty experience of managing that contract and try and force the bidder out of the process because they've had a poor experience with them in the past, which may be a personality clash and may not necessarily be for performance. So it goes back to sort of verification point, but also just having a formal separation between contract managers and procurers, so that if there is any suggestion of bias, you can address it immediately by saying it's not the same people that are involved. Because I have seen it argued in cases that does constitute a conflict of interest if the same person is doing the re-procurement and has built up an unsavoury relationship before that.
Fair point. It would be taken into account, wouldn't it? I think if there was a challenge. So coming to our last topic for today, which is consortia bidding. There's a lot more bullet points on this particular slide because there's quite a lot of detail now in the regulations and in the PPN. But just really to summarise, I mean the core regulations in the PCR 2015 are 19 and 63. 19's basically saying that contracting authorities have the ability to probe the credentials of consortia, and 63 combined with PPN 0816 again, which comes back in this context, in my view, attempts to strike a balance between enabling consortia bids and ensuring that contracting authorities are satisfied that the consortia will meet the specification requirements. That's a fairly high-level summary, but I think it'll probably do us for today. And then there are a number of points in the PPN as well about consortia or group bids, which I won't go through now, but some of the headline points are on the slide. And Michael Bowsher again has kindly agreed to step into this one, and we've got a few points on consortia bids. And the first one is, what should a local authority look at when the lead contractor in a consortium also submits a bid in its own right, or says it's going to do so? Any thoughts on that one, Michael?
I was tempted to sort of dodge this one. I mean, it's a difficult question to ask as a simple theoretical question, because it really depends on what are you asking for and from whom are you asking it. Because and in some member states there's legislation specifically prohibiting these sorts of this from happening. I mean, the obvious alarm is, why are they doing this, and how are they dealing with the obvious competition law problems which are going to be thrown up? And I sort of almost stop there, because until I work out what market I'm in and what the answers are to those two questions, I'm not sure what I should be saying. There may be very sound reasons for doing this, but I need to know the answer to those questions first. I mean, if you took it in, it were in construction, for example, it was civil engineering, and you had a civil engineering contractor appearing in two consortia or in one consortium and once on its own, you might immediately think, well, this is you need some pretty good explanations as to how you were going to deal with the competition law issue first.
Yeah.
I mean, I hesitate to say no, but I'm a bit worried. Would be the start, which presumably is why so many member states have legislation just banning it, because they take the view that contracting authorities shouldn't be put in the position of thinking about it. But I mean, there obviously are situations when it does. I mean, to take out the other extreme, it's not the question, because the question deals with local authorities, but if we were to go into defence, for example, that certainly does happen in defence. You will have situations where you'll have bidding entities, which often are different consortia, may involve a number of different people.
Yes.
Who appear more than once, and you will have situations, and this of course only deals with part of the problem, because even, going back to my civil engineering example, you'll often find that it's the same subcontractors for all the different consortia, and so you feel that often, in practical terms, you have the problem just to just the same extent, because however far you've gone to try and make the consortia different, you still have the coordination, because in fact all the bids are coming from the same subcontractor. So this is a very big problem, I think, is what I would say.
No, we were just looking at factors there, and then you flagged up a number of key factors that have to be considered with it. I don't think anyone could expect a definitive answer to that question in 5 minutes, but it is problematic, and as you say, it does occur reasonably regularly, and certainly exercises some of our subscribers. Moving on to a slightly different point, and this one turns on whether or not contracting authorities have the ability to effectively tell bidders that they will use specifically identified subcontractors for the provision of a particular service. That's almost a bit like an old sort of fashion nomination arrangement in a way. It appears that some local authorities, public bodies, still have a preference for this type of approach in terms of being able to control or be pretty confident about the supply chain.
Well, I mean, I think my problem with that is, again, how does this differ from telling a tenderer that it has to use pipes made from a local, to comply with a local national standard? I mean, it may be that you want to have certain control, you want to see that supply chains are controlled and so forth. But if the contracting authority is going to specify the supply chain, it's going, at least prima facie, you've got a flat-out departure from treaty principles. At least for a few more months, that's a problem. Leaving aside anything else that's in the legislation, I mean, as it seems at a high level, that's a problem. Again, I hesitate to say no, because there can be, as you say, it's actually quite common, and often common in circumstances where you actually unpack why it's being done, it begins to make sense, and you think, okay, I can see why that needs to be done, and probably this is a proportion. But I mean, when you start getting into proportionate departures from free movement principles, it's quite a serious issue.
Yeah, sure.
I mean, we've had it in the local authority kind of repairs and maintenance market, where they have actually gone out and EU tendered their supply chain, so certain suppliers of, kitchens or bathrooms. Sure,
so, then they're saying effectively use our framework. Will.
And so if you're marrying to EU procured, a main contractor, an EU procured main contractor with an EU procured supply chain, fine, that doesn't kind of offend treaty principles. But yes, as Michael said, straight nomination, even if you put the magic words or equivalent after, often, it's not.
It's almost less meaningful when you say, use Rebecca or equivalent. Well, there isn't, how could that be? That doesn't make sense.
Pay you off.
Unique.
Exactly.
Then the next question is the level of proof or required documentation that an authority should require that a bidder is basically going to be able to rely on the capacity of members of a consortium.
I presume this is a reference to what extent contractually or otherwise do you need to be able to show that the other entities are actually going to do what they say they will do. And I always find this a little bit tricky, because it's unreasonable to ask for a contract, and so it's it's a question which you can give an answer and then actually think about it. That's unreasonably demanding, because you couldn't possibly produce that document at this stage in the process. And I'm often surprised that this hasn't come up more often in a sense, particularly going back to our first point, where you'll often have subcontractors who it turns out are essential to pre-qual compliance on more than one for more than one bidder. I don't know what other people think. I mean, it oddly has not been tested. So I tend, in reality, probably all you're really ever going to be able to produce, if it's a one-off contract, is some sort of written assurance from the subcontractor or supplier that they'll be there and they will sign up to an appropriate contract as and when. Because why would they sign up to a contract, to a subcontract or whatever in advance? Obviously, it's different if it's an existing supply chain and you can say, well, we're going to rely on our existing supply chain, which we have on board, and here it all is. But I think that's not really the tenor of this question. This is more what you do at the other end.
I've come across a number of memoranda of understanding in that context. Yeah.
But I mean, how much more? Sorry, how much more solemn is how much more solemn is a memorandum of understanding than a letter from the managing director of the supplier saying yes, we'll do it? I mean, none of them really mean they're never going to be more than agreements to agree, and probably only unilateral, and probably actually only ever unilateral offers of an agreement to agree or something.
Yeah, on a conditional basis.
Yeah.
That's right. I mean, practically, often when you have the consortium, you'll be getting selection questionnaires from all members of the consortium. So you do have a level of assurance that they haven't just bunged somebody's name in without considering it, that they do actually know that they are being put forward as part of the consortium. But I think if we move on to the next question, that's how we normally get our clients comfortable with it, in the sense that unless you are particularly saying that a member of the consortium is indispensable in the delivery of the contract, then the protections that you write into your procurement process around changes in consortium normally reassure a nervous client about changes in the consortium.
And as Rebecca says, it's finding a way of matching out that sort of what's an acceptable substitute, and trying to, and there we do have a sort of at least one case to test that against. We have poor Mr. Val and his super duper toilet technology in Frankfurt, and we know that he was the sub-supplier who was shifted out and successfully demonstrated that he shouldn't have been. So he is the I can't now remember, but presumably he did produce. There was a document that showed that he was going to be available to provide his super duper toilet technology. And then
there was like a letter of reliance.
Some sort, exactly, and then it just wasn't called upon, and cheapo was put in its place. As Rebecca says, the way that should have been dealt with is by means of some sort of a means of testing the appropriateness of swapping someone in or out.
And the test that we always advise our clients to apply in any sort of change to the bidding entity, including on solvency and novation, is the level of selection criteria. So would they pass the pre-qualification questionnaire in terms of financial robustness, technical capacity, all those self-hygiene kind of questions as well. So
bearing in mind also that if you bear in mind Mr. Val, you also have to have did that particular supplier bring something to the consortium that was relevant, decisive, I don't know what adjective to the outcome, which plainly in the Frankfurt case, Mr. Val did.
I think we're just about coming to the end of our time now. I'm not sure if we have got time to deal with this last question. If not, we can deal with it separately in terms of consortium membership changes in the course of a procurement. I think we've already touched on that to a certain extent. And so just remains for me, I think, to thank everybody for coming into this webinar today, and a big thank you to the people here, the two Michaels and Rebecca, who've answered all these really difficult questions brilliantly, if I may say so. And to say that if there have been a number of questions that have been coming in the course of the webinar, we'll collect them up and aim to deal with them separately. So thank you very much to everybody, and goodbye.